Case 1. Pearl Sinthia Fernandez, May 22, 2013, Los Angeles County Superior Court. There are moments in the history of a community when the justice system is forced to confront a reality so painful, so difficult to process, that the weight of it lingers for years, not just in courtrooms and case files, but in the hearts of everyone who followed the story. The case of Pearl Sinthia Fernandez is one of those moments. It is a case that shook the city of Los Angeles, galvanized child welfare advocates across the entire state of California, and ultimately forced an honest and uncomfortable reckoning with the systems that are supposed to protect the most vulnerable among us. This is a story about accountability. It is a story about the failure of institutions and the resilience of a community that refused to look away. And most of all, it is a story about a child named Gabriel, a little boy who deserved every protection the world could offer, and who was failed by the one person in his life who was supposed to love him most. Gabriel Fernandez was born on February 20th, 2005, in Los Angeles County. By all accounts from neighbors, teachers, and community members who later spoke to investigators, Gabriel was a bright and curious child. He had a smile that people remembered. He was the kind of kid who said good morning to strangers and who, despite everything that was happening in his young life, showed up to school and tried. That detail alone, that despite what was being done to him behind closed doors, he still showed up, would later become one of the most heartbreaking threads in the entire investigation. Gabriel had been living with relatives before he was returned to the custody of his mother, Pearl Sinthia Fernandez, in the spring of 2012. He was 7 years old. Pearl, at the time, was living with her boyfriend, Aguilar, in an apartment in Palmdale, in the Antelope Valley region of Los Angeles County. Palmdale, a suburban city roughly 60 miles northeast of downtown Los Angeles, is a community of working families, desert landscapes, and wide residential streets. It is not the kind of place most people would associate with the kind of sustained cruelty that investigators would later uncover inside that apartment. From the moment Gabriel moved in, neighbors and school officials began noticing things that did not sit right. He came to school with injuries. He came to school dirty and hungry. He told teachers things that were reported to the Los Angeles County Department of Children and Family Services on multiple occasions. Over the course of roughly 8 months, child welfare workers visited the home at least 8 times. Each time, the case was closed without protective action. That fact, those 8 visits, those 8 closed cases, would later become the center of one of the most significant child welfare reform conversations in California history. On the evening of May 22, 2013, emergency services received a call from the Palmdale apartment. Gabriel, 8 years old, had been brought to the hospital in critical condition. He was unresponsive. He had suffered what medical personnel described as injuries consistent with prolonged and severe mistreatment. He was placed on life support. 2 days later, on May 24, 2013, Gabriel Fernandez did not survive. He was 8 years old. The investigation that followed was thorough and methodical. Detectives from the Los Angeles County Sheriff's Department processed the apartment and interviewed witnesses. What they documented inside that home was a pattern of sustained harm carried out over months. Evidence gathered by investigators indicated that Gabriel had been subjected to extreme physical harm on a repeated basis, harm that included burns, injuries to multiple parts of his body, and conditions of deliberate deprivation. Medical examiners, child welfare specialists, and law enforcement personnel all contributed to a case file that painted a devastating picture of what life had been like for Gabriel in that apartment. Pearl Sinthia Fernandez was arrested shortly after Gabriel was taken to the hospital. Aguilar was arrested as well. Both were charged in connection with Gabriel's death. The prosecution, led by the Los Angeles County District Attorney's Office, built a case around the evidence gathered inside the apartment, medical records, school documentation, and the testimony of witnesses. In February of 2018, Pearl Sinthia Fernandez pleaded guilty in Los Angeles County Superior Court to first-degree murder. She was sentenced to life in prison without the possibility of parole. In entering her plea, she acknowledged her role in what had happened to her son. There was no trial for Pearl. Her guilty plea was entered in a courtroom where the weight of what had been done to Gabriel hung over every moment of the proceeding. Aguilar was separately convicted at trial and was also sentenced to life in prison without the possibility of parole. The 4 Los Angeles County social workers who had been assigned to Gabriel's case were also charged criminally, marking one of the very rare occasions in American legal history where child welfare officials faced criminal prosecution for failing to protect a child. While those prosecutions ultimately did not result in convictions on the most serious charges, their very existence sent a message that the community of Los Angeles was demanding change. The cases against the social workers were scrutinized extensively in both legal and public policy circles. In the years following Gabriel's death, the state of California passed what became known informally as Gabriel's Law, a package of reforms aimed at strengthening mandatory reporting requirements, improving interagency communication between law enforcement and child protective services, and increasing accountability within the foster care and child welfare systems. Gabriel's name became synonymous with the kind of systemic reform that saves lives. Advocates, legislators, and community organizations cited his case in pushing for changes that extended well beyond Los Angeles County and touched child welfare policy at the state level. Netflix released a documentary series about Gabriel's case in 2020, bringing the story to an international audience. The series examined not only what happened to Gabriel, but also the systems, family, institutional, governmental, that allowed it to happen. The documentary renewed public calls for accountability and sparked conversations about the obligations of communities, schools, and government agencies to protect children who cannot protect themselves. Then, in March of 2026, the case returned to public attention once more. Sinthia Fernandez had filed a second petition for resentencing under California law. Her legal team argued that she was entitled to relief under provisions that allow courts to reconsider sentences in certain circumstances. On March 30, 2026, a judge in Los Angeles County Superior Court denied that petition. The ruling was clear and direct. Fernandez was ineligible for resentencing relief because the evidence established that she had personally and directly participated in the harm that led to Gabriel's death. She would remain in prison for the rest of her natural life. For the advocates, the community members, and the people who had followed Gabriel's story for over a decade, that ruling carried a particular kind of weight. It was not a moment of celebration. Nothing about this case invites celebration, but it was a moment of confirmation. The court system, after reviewing every argument presented on Pearl's behalf, looked at the record and said, "The accountability that was imposed is the accountability that is required." Gabriel Fernandez would have been 21 years old in 2026. He never got the chance to grow up, to discover who he was going to become, to build a life of his own. What he left behind is a legacy of reform, a community that demanded better, and a legal record that stands as one of the most significant child welfare cases in the history of Los Angeles County. When we talk about child safety in this country, when we talk about the obligations of neighbors, teachers, doctors, and public servants to speak up and act, we talk about Gabriel. His name carries meaning. And the systems that exist today in California to protect children are, in small but real ways, shaped by what he endured and what his community refused to forget. If you or someone you know has concerns about the welfare of a child, the Child Help National Child Abuse Hotline is available 24 hours a day, 7 days a week, at 1-800-422-4453. You do not need to be certain. You just need to make the call. The justice system, imperfect as it is, did ultimately hold Sinthia Fernandez accountable. She is serving life without the possibility of parole in a California state prison. The court's most recent ruling in 2026 confirmed that accountability will not be undone. For Gabriel, and for every child whose story echoes his, we keep telling these stories, not for shock, not for spectacle, but because awareness is the first step toward protection. If this story moved you, if it made you think about the children in your own community and the systems we build to keep them safe, please take a moment to like this video and subscribe to Cold Case Hour. Every view, every subscription, every share helps this channel continue doing the work of documenting these cases and keeping these conversations alive. Don't forget to hit the notification bell so you never miss an episode. Case 2. Liliana Carrillo, April 10, 2021, Los Angeles County Superior Court. There are cases that arrive in the public consciousness with a kind of stunned silence. Cases where the facts, once laid out in sequence, produced not just grief but a deep and unsettling confusion about how a tragedy of that scale could have unfolded. The case of Liliana Carrillo is one of those cases. It arrived in the spring of 2021 in the Reseda neighborhood of Los Angeles' San Fernando Valley, and it left behind 3 small children who never had the chance to grow up, a family shattered across state lines, and a legal process that has continued to raise difficult questions about mental health, the court system, and the gap between the two. Liliana Carrillo was a young mother living in Reseda, a community in the western portion of the San Fernando Valley, roughly 25 miles from downtown Los Angeles. She had 3 children, a daughter who was 3 years old, a son who was 2 years old, and an infant daughter who was just 6 months old. All 3 children were, by every account from family members and those who knew them, healthy and young and full of life. They were the kind of small children who filled a space with noise and movement and the particular energy of early childhood, the kind of presence that makes a home feel alive. In the months leading up to April of 2021, Liliana Carrillo and the father of her children, Eric Denton, were engaged in a difficult and contested custody dispute. Court records and statements made by family members to investigators describe a relationship that had deteriorated significantly, one marked by conflict, legal filings, and deeply competing claims about the welfare of the children. Carrillo, according to statements she later made, believed that the children were being subjected to harm during their time with their father, allegations that were disputed and that had not been substantiated through the court process at the time of the events of April 10th. On the morning of April 10, 2021, emergency services were called to the apartment in Reseda. What responding officers found when they entered the residence was a scene that would be described by law enforcement personnel as one of the most devastating they had encountered. All 3 children, the 3-year-old, the 2-year-old, and the 6-month-old infant, had lost their lives. They were found in the apartment. Liliana Carrillo was not present. A search was immediately launched. Carrillo had left the Los Angeles area. She was located by law enforcement in Tulare County, in California's Central Valley, several hours after the children were found. She did not resist arrest. She was taken into custody and transported back to Los Angeles County. What happened in the days and weeks that followed added another layer of complexity to an already devastating situation. In a recorded jailhouse interview, a video that was later obtained and reviewed by media outlets, Liliana Carrillo spoke directly and at length about what she had done. Her words were not the words of someone who denied responsibility. She acknowledged, in that interview, that she had taken the lives of her 3 children. She described her reasoning in terms that were deeply disturbing and deeply revealing at the same time. She stated that she had done what she did in order to protect her children. She said she believed that by ending their lives, she was shielding them from harm she was convinced was being done to them by their father. That statement, the claim that the act was one of protection rather than harm, became central to the legal proceedings that followed and to the public conversation that surrounded the case. Child welfare advocates, mental health professionals, legal scholars, and members of the public all grappled with the same painful question. What does it mean when a mother believes, however incorrectly, however tragically, that the most harmful thing she can do is also the only protective option available? That question does not have an easy answer. It does not excuse what happened, but it is a question that the legal system has been required to engage with seriously. Carrillo was charged with 3 counts of murder in Los Angeles County Superior Court. Her legal team entered a not guilty plea and signaled from early in the proceedings that mental health would be central to her defense. The case entered a lengthy period of pretrial motions, competency evaluations, and legal proceedings that have extended over multiple years. As of the time this documentary was produced, Liliana Carrillo's trial had not yet concluded in Los Angeles County Superior Court. The legal process has been complicated by ongoing questions about her mental state, both at the time of the events of April 10, 2021, and in the period since her arrest. Mental health evaluations ordered by the court have been part of the record. Her legal team has continued to pursue a defense that centers on her psychological condition and her stated belief that she was acting to protect rather than harm her children. The children, the 3-year-old girl, the 2-year-old boy, and the 6-month-old infant, are remembered by family members as bright, beloved, and cherished. Their father, Eric Denton, gave interviews in the period following the events in which he described his children with the kind of specific, personal detail that only a parent knows. The way the oldest loved to dance, the way the baby laughed, the particular personality of each of them. His grief, documented across multiple interviews and statements, is the grief of a parent who lost everything on a single morning and has had to watch the legal process move forward slowly in the years since. The case of Liliana Carrillo has also become a reference point in broader conversations about the intersection of mental health crisis and the family court system. Advocates who work with families navigating custody disputes, particularly disputes that involve allegations of child abuse or intimate partner harm, have pointed to this case as an example of the catastrophic consequences that can result when a person in psychological crisis does not receive adequate intervention. Whether the systems available to Carrillo before April 10th of 2021 were adequate, whether there were warning signs that went unaddressed, whether mental health resources were accessible and sufficient, these are questions that researchers, policy advocates, and community organizations have continued to examine. The children of Reseda deserve to be more than a case number. They deserve to be remembered as children, small, irreplaceable, and gone too soon. The legal process that continues to unfold in Los Angeles County Superior Court is, in its imperfect way, an attempt to answer for what happened to them. However that process concludes, the loss at the center of it cannot be undone. 3 children who should be alive are not. A family that should have been whole is broken. And a community is left, as communities so often are in the aftermath of these tragedies, asking what more could have been done. Child advocates and mental health organizations across Los Angeles County have continued to call for increased funding and accessibility for mental health services, particularly for parents navigating high-conflict family court situations. The case of Liliana Carrillo is part of that advocacy conversation, held up not as an excuse, but as evidence of what is at stake when mental health crises go unaddressed. If you are a parent in crisis, if you are navigating a situation that feels impossible and overwhelming, please reach out. The crisis text line is available by texting HOME to 741741, 24 hours a day. Help is available. You do not have to face it alone. The justice system is working through the case of Liliana Carrillo. When that process concludes, this channel will continue to cover the outcome with the same commitment to accuracy and responsibility that we bring to every case. For now, what matters most is remembering the 3 children at the center of this case and committing, as a community, to building better systems of support so that no family arrives at a moment like this one again. If this case has moved you, if it has made you think about the importance of mental health resources and community support systems, please like this video and subscribe to Cold Case Hour. Your support keeps this channel running and these stories being told. Don't forget to leave a comment and hit the notification bell. Case 3, Caro and Coronado, May 20th, 2014, Los Angeles County Superior Court. In the spring of 2014, the community of Torrance in Los Angeles County was confronted with a tragedy that sent shockwaves through the region and raised profound and difficult questions about maternal mental health, postpartum illness, the boundaries of criminal culpability, and the obligations of the communities and medical systems that surround new and struggling mothers. The case of Caro and Coronado is, by any measure, one of the most devastating cases in Los Angeles County's modern legal history, not only because of the profound loss at its center, but because of the medical and legal questions it forced into the open, questions that remain deeply contested and urgently relevant. Caro and Coronado was 22 years old in May of 2014. She was a young mother living in an unincorporated area of West Carson, which falls within the jurisdiction of Los Angeles County, adjacent to the city of Torrance. She had 3 daughters, a 2-year-old, a 16-month-old, and an infant daughter who was just 2 months old. The weight of caring for 3 children under the age of 2, 3 children born in rapid succession, with the youngest barely weeks old, is a weight that child development specialists and maternal health advocates describe as among the most demanding circumstances a parent can face, particularly without adequate support. On the afternoon of May 20th, 2014, Caro and Coronado's mother arrived at the home. What she found inside that residence prompted an immediate call to emergency services. Coronado was found inside the home with her 3 daughters, all of whom had suffered fatal injuries. She was found holding the infant. Law enforcement personnel who responded to the scene described what they encountered as one of the most difficult calls of their careers. All 3 children had lost their lives. Carol and Coronado was taken into custody. She did not flee. She did not resist. She was present in the home when her mother arrived and when law enforcement responded. Those facts, the staying, the not running, the being found holding her youngest, would become part of the complex portrait that emerged as investigators, prosecutors, and defense attorneys attempted to understand what had happened in that home. Coronado was charged in Los Angeles County Superior Court with 3 counts of first-degree murder. Her defense team immediately and consistently argued that Coronado had been in the grip of a severe postpartum psychotic episode at the time the events of May 20th occurred. Postpartum psychosis is a recognized and serious psychiatric condition, distinct from and significantly more severe than the more commonly discussed postpartum depression, that can involve hallucinations, delusions, disorganized thinking, and a profound break from reality. Medical literature on the condition describes it as a psychiatric emergency that, when left unaddressed, can have catastrophic consequences. Coronado's defense presented extensive psychiatric testimony arguing that she had been experiencing a psychotic break on the day of the tragedy, that her perception of reality had been so severely disrupted by her mental state that she could not be held criminally responsible in the traditional legal sense. Expert witnesses called by the defense testified about the nature of postpartum psychosis, its symptoms, its progression, and its potential consequences. Her legal team argued that what happened was the result of an acute psychiatric crisis rather than criminal intent. The prosecution's position was different. Prosecutors argued that the evidence did not support a finding of legal insanity and that Coronado had been legally sane at the time of the events. They presented their own expert testimony and argued that the legal standard for insanity, which in California requires that a defendant did not know or understand the nature of the act, or did not understand that it was wrong, had not been met by the evidence in the case. The case proceeded over a period of years, involving multiple hearings, competency evaluations, and legal proceedings before a judge in Los Angeles County Superior Court. In a ruling that drew significant attention from mental health advocates, legal scholars, and members of the public who had followed the case closely, the presiding judge ultimately found that Carol and Coronado was legally sane at the time of the crimes. That finding, based on the application of California's legal insanity standard to the evidence presented, meant that the legal system had determined she was criminally responsible for what had happened. Carol and Coronado was sentenced to 3 consecutive terms of life in prison without the possibility of parole, 1 term for each of her 3 daughters. The sentence meant she would spend the rest of her natural life incarcerated in a California state prison, without any opportunity for release. The reaction to the verdict and sentence was not uniform. Mental health advocates expressed concern that the case reflected the difficulty, some would say the inadequacy, of the legal system's treatment of severe psychiatric illness, particularly in the context of postpartum conditions. They argued that a woman in the depths of a genuine psychotic episode is not a criminal in any meaningful moral sense, and that her case should have been treated as a medical emergency from the start. Legal professionals on the other side of the debate argued that the court applied the standard as written and that the verdict reflected the evidence presented. The case of Carol and Coronado became a reference point in discussions about maternal mental health policy in California and nationally. Maternal health advocates, postpartum support organizations, and psychiatric professionals have cited the case in pushing for greater awareness, greater access to screening, and greater resources for mothers experiencing mental health challenges in the perinatal period. The argument that runs through those advocacy conversations is straightforward and powerful. If the systems of support and medical intervention had been adequate, if postpartum psychosis were as well understood by the general public as postpartum depression, if screening were more robust, if access to treatment were less fractured, there is a possibility, and perhaps more than a possibility, that the events of May 20th, 2014 never would have occurred. 3 little girls, ages 2 years, 16 months, and 2 months, are gone. Their names belong to a family's private grief. What their loss left behind in the public record is a legal precedent, a policy debate, and an ongoing conversation about how California and the nation treat mothers experiencing acute psychiatric emergencies. That conversation has not been resolved. It is still happening. And the 3 children at the center of it deserve for it to continue. Not as a means of excusing what happened, but as a means of ensuring that other families are protected by systems strong enough to intervene before tragedy arrives. Carol in Coronado is serving 3 consecutive life sentences without the possibility of parole in a California state correctional facility. She will not be released. The court has spoken. For those who believe the sentence reflects justice, it stands as accountability for the loss of 3 children who had barely begun to live. For those who believe it reflects a systemic failure to treat mental illness as the medical emergency it is, it stands as a call for reform. Both things can be true at once. The children are gone. The woman who harmed them is imprisoned for life. And the systems that surrounded her before May 20th are still, in too many places, inadequate. That is what this community, and communities like it, must grapple with. Postpartum Support International offers resources for mothers and families dealing with perinatal mood and anxiety disorders, including postpartum psychosis. Their helpline is available at 1-800-944-4773. If you or someone you know is struggling after the birth of a child, please reach out. These conditions are treatable. Help is available. Carol in Coronado is imprisoned for life. Her daughters are remembered. The conversation their case ignited continues. If this story has resonated with you, if it has made you think about the mental health resources available to mothers in your community, please take a moment to like this video and subscribe to Cold Case Hour. Don't forget to leave a comment. Your thoughts and perspectives matter. We'll see you in the next case. Case 4, Angela Dawn Flores, May 8, 2022, Los Angeles County Superior Court. There are moments in the history of a city when a tragedy arrives that defies easy categorization. A case that does not fit neatly into the familiar narrative frameworks of crime and punishment, sanity and culpability, premeditation and impulse. The case of Angela Dawn Flores, which unfolded on Mother's Day of 2022 in the West Hills neighborhood of Los Angeles, is one of those moments. It is a case that has forced the Los Angeles County legal system, mental health professionals, and the broader public to grapple simultaneously with the deepest kind of loss and the most difficult questions about what it means to stand accountable before the law when the mind itself is at the center of the tragedy. West Hills is a neighborhood in the western San Fernando Valley, a suburban community of quiet residential streets and family homes, the kind of neighborhood where children ride bikes and neighbors wave from driveways. It is not a place that prepares its residents for the kind of news that arrived on the morning of May 8, 2022. Angela Dawn Flores was a mother of 4. Her children ranged in age from 8 years old to 16 years old. Her daughter was 12. Her 2 younger sons were 8 and 10. Her eldest child, a 16-year-old son, was also present in the home on the day the events of May 8 occurred. Law enforcement received a call on the morning of Mother's Day, 2022. When officers arrived at the residence in West Hills, they discovered that 3 of the 4 children, the 12-year-old daughter and the 8 and 10-year-old sons, had lost their lives. Angela Dawn Flores was present at the scene. She did not flee. When investigators spoke with her, she provided a statement that would become one of the most disturbing and contested elements of the entire case. Flores told authorities that she believed her 3 children had been possessed by demonic forces. She stated that her actions were not acts of harm but acts of protection, that she had acted, in her own mind, in the belief that what she was doing was spiritually necessary to deliver her children from an evil that she believed had taken hold of them. The 16-year-old son, who was present in the home, was alleged by investigators to have assisted his mother during the events of that morning. The statement Flores made to investigators, and the framing she offered for what had occurred, placed the case immediately at the intersection of criminal law and mental health. Prosecutors and defense attorneys, from the earliest stages of the proceedings, recognized that the question of her mental state on the morning of May 8 was going to be central to everything that followed. Angela Dawn Flores was charged in Los Angeles County Superior Court with multiple counts of murder. Her legal team entered a plea of not guilty by reason of insanity, one of the most consequential and carefully scrutinized pleas available under California law. The not guilty by reason of insanity plea does not deny that the acts occurred. It asserts, rather, that at the time the acts occurred, the defendant's mental state was so severely compromised, so disconnected from reality, that the legal standard for criminal responsibility was not met. In California, the legal standard for an insanity defense requires that the defendant, at the time of the act, either did not understand the nature of the act or did not understand that the act was wrong. It is a high standard, intentionally so, and it requires extensive expert testimony, psychiatric evaluation, and legal argument to be established in court. The Flores case triggered exactly that kind of intensive examination. In the period following her arrest and initial court appearances, proceedings in the Flores case were significantly affected by questions about her mental competency, not just at the time of the events of May 8th, but in the present, as the court attempted to evaluate her fitness to stand trial. California law requires that a defendant be mentally competent to stand trial, to understand the nature of the proceedings against her, and to be able to assist in her own defense. When questions about competency arise, they can substantially delay and complicate the path toward trial. The case of Angela Dawn Flores remained in pretrial proceedings as of the time this documentary was produced. Legal proceedings regarding her mental competency continued, and no trial date had been confirmed. Her eldest son, the 16-year-old who was alleged to have been involved in the events of May 8th, faced separate legal proceedings through the juvenile justice system, given his age at the time. The three children at the center of this case, the daughter, 12 years old, and the two boys, 8 and 10, are remembered by family members, school communities, and neighbors as ordinary children living ordinary childhoods in a West Hills neighborhood on a Sunday morning. The particular cruelty of the timing, Mother's Day, a day that in millions of households across the country carries associations of celebration and love and family, added a layer of painful irony to the grief that settled over the community in the aftermath of that morning. The case has become part of a broader conversation about the intersection of religious delusion, severe mental illness, and criminal responsibility. Legal scholars and mental health professionals have pointed to the Flores case as an example of why the criminal justice system's tools for addressing severe psychiatric conditions are in need of ongoing evaluation and refinement. The debate is not about whether accountability is required. Accountability is required, but about what form that accountability takes when the person being held accountable may have had no meaningful contact with reality at the time the harm occurred. The children of West Hills did not deserve what happened to them on Mother's Day of 2022. They were children. They had their whole lives ahead of them. A 12-year-old girl, a 10-year-old boy, an 8-year-old boy, gone on a Sunday morning in a neighborhood that had no reason to expect what that day would bring. Their absence from the world is a loss that no legal outcome, however just, can undo. The proceedings in Los Angeles County Superior Court continue. When this case reaches its conclusion, this channel will document that outcome with the full seriousness and care it deserves. For now, what this community is left with is grief, questions, and the ongoing obligation to build mental health systems robust enough to identify and intervene before a family arrives at a moment like this one. If you or someone you know is experiencing a mental health crisis involving religious delusion or psychotic symptoms, please contact the National Alliance on Mental Illness Helpline at 1-800-950-6264, Monday through Friday, 10 a.m. to 10 p.m. Eastern Time. Crisis intervention is available. These conditions are recognizable. These conditions are treatable. Reaching out saves lives. The three children of West Hills are gone. The legal process continues. And the community of Los Angeles continues to ask the questions that this case demands be asked. Please like this video, subscribe to Cold Case Hour, and leave a comment below. Don't forget to hit the notification bell so you never miss a new episode. Case 5. Natalie Brothwell, November 29, 2020, Los Angeles County Superior Court. There are cases that arrive in the public record carrying a weight so extraordinary, so far outside the boundaries of what the human mind is prepared to absorb, that even experienced investigators, seasoned prosecutors, and veteran journalists struggle to find language adequate to the facts. The case of Natalie Brothwell and her husband Maurice Taylor Sr., which came to the attention of law enforcement in Lancaster, Los Angeles County, on November 29, 2020, is one of those cases. It is a case that sat in the legal system for more than 5 years before sentencing was handed down in February of 2026. And in every one of those 5 years, the details of what investigators found in that Lancaster home continued to represent one of the most severe instances of child harm in the modern history of Los Angeles County. Lancaster is a city in the Antelope Valley, in the high desert region of northern Los Angeles County. It is a community of wide streets, open skies, and residential neighborhoods that stretch out under the Mojave sun. It is the kind of city where a family can live for years without drawing the attention of neighbors, where the distance between houses and the ordinary privacy of residential life can mean that what happens behind closed doors stays behind closed doors, sometimes for far too long. Natalie Brothwell and Maurice Taylor Sr. were a couple living in Lancaster with their children. Among their children were four who would become central to the events of November 29, 2020, two of them aged 12 and 13, and two younger siblings who survived. What investigators found when they responded to that Lancaster address on November 29 would result in one of the most significant criminal prosecutions in Los Angeles County in recent years. The two older children, the 12-year-old and the 13-year-old, had lost their lives. The circumstances of their deaths, as documented by investigators and presented in court proceedings, were of a nature that the Los Angeles County District Attorney's Office described as among the most severe they had prosecuted. Both children had suffered injuries that medical examiners and forensic investigators characterized as extensive and the result of deliberate harm. The two surviving children were found in conditions that indicated they had also been subjected to harm and deprivation over a period of time. They were removed from the home and placed into protective care. Natalie Brothwell and Maurice Taylor Sr. were both arrested and charged with murder in connection with the deaths of the two older children. They were also charged with crimes relating to the harm suffered by the two surviving children. The cases against both defendants were prosecuted in Los Angeles County Superior Court. The proceedings were lengthy and complex, involving extensive forensic evidence, expert testimony, and legal arguments that unfolded over a period of years. In February of 2026, more than 5 years after the events of November 29, 2020, Natalie Brothwell and Maurice Taylor Sr. were each sentenced to life in prison without the possibility of parole. The sentences were handed down in Los Angeles County Superior Court. The judge, in delivering the sentences, reflected on the nature of the harm that had been done to the children and the obligations of the justice system to respond with the full measure of accountability available under California law. Life without the possibility of parole is the most severe sentence available in California in cases where the death penalty is not sought or imposed. It means exactly what it says. Natalie Brothwell and Maurice Taylor Sr. will spend the remainder of their natural lives in California state correctional facilities. They will not be released. They will not have opportunities for parole review. The accountability imposed by the court in February of 2026 is the accountability that will define the remainder of their lives. The two surviving children from that Lancaster home, younger siblings of the children who lost their lives, were placed into protective care and have been the subject of ongoing attention from child welfare agencies and family court proceedings in the years since November of 2020. Their well-being, their healing, and their futures are part of the ongoing human story of this case. A story that does not end with a sentencing hearing, but continues in the lives of children who experience things no child should ever experience, and who now carry that weight as they move through the world. The case of Natalie Brothwell and Maurice Taylor Sr. has been cited by child welfare advocates and law enforcement officials in Los Angeles County as an example of why community awareness, neighbor engagement, and robust child welfare systems matter. The harm in that Lancaster home did not occur overnight. It occurred over time. And the question that advocacy organizations have continued to ask in the aftermath of this case is the same question they ask after every case of prolonged child harm. What were the signs? Who might have seen them? And what systems need to be strengthened so that the next time those signs appear, someone intervenes before it is too late? The children who lost their lives in Lancaster on November 29, 2020 were 12 and 13 years old. They were young people on the edge of adolescence, at an age when the world should have been opening up to them, when friendships and discoveries and the particular expanding awareness of the teenage years should have been their experience. Instead, they experienced the opposite, a home that was not safe, adults who were supposed to protect them who instead caused them catastrophic harm, and ultimately a loss of life that no court ruling can restore. Their names belong to their family's grief. Their story belongs to the public record of Los Angeles County and to the ongoing obligation of this community to do better by its children. Natalie Brothwell is in prison for the rest of her life. Maurice Taylor Sr. is in prison for the rest of his life. The sentences handed down in February of 2026 are final. The children they harmed are remembered. If you have concerns about the welfare of a child, please contact the Los Angeles County Department of Children and Family Services at 1-800-540-4000 or call the Child Help National Child Abuse Hotline at 1-800-422-4453. Every call matters. Every report matters. Please like this video and subscribe to Cold Case Hour. Leave a comment and share this video with someone who cares about child safety and community accountability. Don't forget to hit the notification bell to stay updated on every new case we cover. Case 6. Carmen Anita Degregg, January 6, 2026, Los Angeles County Superior Court. Among the cases that have made their way into the Los Angeles County court system in recent years, there are some that arrive with a particular and immediate urgency. Cases so recent that the grief surrounding them has not yet had time to settle into the longer arc of legal proceedings and public reckoning. The case of Carmen Anita Degregg is one of those cases. It entered the public record on January 6, 2026, in the coastal community of Santa Monica, and at the time this documentary was produced, it remained in its early stages before Los Angeles County Superior Court. But its presence in this documentary is appropriate and necessary because the facts as established through criminal charges and court proceedings reflect the loss of a 17-month-old child, that demands to be acknowledged with the full seriousness that any loss of a child deserves. Santa Monica is one of Los Angeles's most recognizable communities. It sits on the edge of the Pacific Ocean, a city of beach walkways, bustling commercial streets, and residential neighborhoods that stretch from the coast inland. It is a city associated in the popular imagination with sunlight and openness and the particular quality of life that proximity to the ocean brings. It is not a city that prepares its residents for the kind of news that emerged in January of 2026. Carmen Anita Degregg was a resident of Santa Monica. She was the mother of a 17-month-old daughter, a toddler, barely past infancy, at the age when children are just beginning to find their footing in the world, when language is emerging and independence is beginning and the world is a place of expanding discovery. A 17-month-old child is entirely dependent. She has no recourse, no ability to protect herself, no capacity to seek help or to understand danger. She depends, absolutely and completely, on the adults around her for safety. On January 6, 2026, emergency services responded to a location in Santa Monica. Degregg's 17-month-old daughter was found to have suffered injuries that were, according to law enforcement and the criminal complaint filed by the Los Angeles County District Attorney's Office, the result of extreme violence. The child did not survive. She lost her life as a result of the injuries she had sustained. Carmen Anita Degregg was arrested. She was charged with murder and felony child assault in connection with her daughter's death. According to court records and information released by the District Attorney's Office, the injuries sustained by the child involved a frying pan. The charges filed against Degregg reflect the District Attorney's assessment that the harm done to her daughter was deliberate and of a severity that meets the legal threshold for murder under California law. Degregg entered a plea of not guilty in February of 2026. Her bail was set at $2 million. As of the time this documentary was produced, she remained in custody, held on that bail amount, awaiting the legal proceedings that will determine the outcome of the case against her. The case is in its early stages. The full development of the evidence, the legal arguments, the hearings, and ultimately any trial or resolution of the charges will unfold over the coming months and potentially years in Los Angeles County Superior Court. As with all cases at the charging stage, the legal principle that a defendant is presumed innocent until proven guilty applies. The charges against Carmen Anita Degregg are serious and specific, and they will be tested through the legal process. What is not in question, what cannot be in question, is the life of the child at the center of this case. A 17-month-old girl in Santa Monica, a toddler who had barely begun her life, a child whose entire existence was defined by dependency on the adults around her, and who on January 6 of 2026 did not receive the protection she depended upon. Her loss is recent. Her memory is raw. And the legal system is, in its methodical and imperfect way, beginning the process of determining what accountability looks like in the face of that loss. The Santa Monica community and the broader Los Angeles community that follows these cases with the combination of grief and civic responsibility that defines the relationship between citizens and the courts in a democratic society will be watching as this case develops. This channel will continue to monitor the proceedings and report on significant developments as they occur. For the advocates and organizations in Los Angeles County who work with families and children in situations of risk, cases like this one are a reminder of why early intervention, accessible family support services, and robust community awareness programs matter. The resources are there, imperfect as they are. The question is always whether they reach the families that need them most before tragedy arrives. If you have concerns about a child's safety, please contact the Child Help National Child Abuse Hotline at 1-800-422-4453. Available 24 hours a day. Every call is confidential. The case of Carmen Anita Degregg is before Los Angeles County Superior Court. A 17-month-old girl is gone. The legal process has begun. We will continue to cover this case with the seriousness and care it demands. Please like this video, subscribe to Cold Case Hour, and leave a comment below. Your support matters, and it keeps this work going. Don't forget the notification bell. Case 7. Socorro, Caro, November 22, 1999, Los Angeles County Superior Court. There are cases that define an era in a region's legal history. Cases that were covered so extensively at the time of their occurrence, tried so publicly, and decided so consequentially, that they remain in the institutional memory of the justice system decades after the jury returned its verdict. The case of Socorro, Caro is one of those cases for Los Angeles County. It began on a night in November of 1999 in the community of Carrillo, and it has wound its way through the California court system for more than 2 decades, through trial, through appeals, through a sentence that has been reviewed, challenged, and ultimately upheld by the highest court in the state. It is a case about a family, about the devastating consequences of adult conflict on children who have no part in that conflict, and about the long reach of accountability under California law. Socorro Caro was a woman living in Carrillo, a suburban community in Ventura County, near the border with Los Angeles County. She was married and had 4 children, sons and daughters whose ages, on the night of November 22, 1999, ranged from 5 years old to 11 years old. By any outward measure, the family was a family living an ordinary suburban life. There were school schedules and homework and the rhythms of a household with children at multiple ages. There was also, according to the evidence presented at trial and the statements gathered by investigators, significant conflict within the marriage. On the evening of November 22, 1999, Socorro Caro and her husband had an argument. The nature of that argument, its content, and its intensity became part of the record in the trial that followed. What is established in the public record is what happened after the argument ended, what happened in the nighttime hours that followed, while the children of that household slept in their beds. 3 of the 4 children, the 5-year-old, the 8-year-old, and the 11-year-old, were shot while they slept. All 3 children lost their lives. The 4th child, Socorro's eldest, survived. When law enforcement responded to the Carrillo address in the early hours of November 23, 1999, they found 3 children who had not survived the night, and a family whose entire world had been changed in the span of hours. Socorro Caro was taken into custody. She was charged with 3 counts of first-degree murder with special circumstances. The special circumstances designation in California is significant because it makes a defendant eligible for the death penalty, the most severe punishment available under California law. The case was transferred from Ventura County to Los Angeles County Superior Court for trial, a venue change that reflected both the magnitude of the case and the legal determinations that preceded the trial. The trial of Socorro Caro was a high-profile proceeding. It drew extensive media coverage and public attention. The prosecution presented evidence of premeditation and argued that the killings were deliberate, planned acts committed in the context of the marital dispute. The defense argued for a different understanding of events, challenging the prosecution's narrative of cold-blooded premeditation and presenting evidence about Socorro's state of mind. The jury heard extensive testimony, reviewed the physical evidence, and deliberated. In 2001, the jury in the Socorro Caro trial returned a verdict of guilty on all 3 counts of first-degree murder. The jury also found true the special circumstances allegations that made her eligible for the death penalty. After the guilt phase of the trial, the jury proceeded to a penalty phase and recommended the death penalty. The court accepted that recommendation and sentenced Socorro Caro to death. The legal journey that followed the 2001 verdict was a long one, as it is in virtually all capital cases in California. Death penalty cases in California are automatically appealed to the California Supreme Court, the state's highest tribunal, which reviews the entire record of the trial for legal errors, constitutional violations, and questions of law. That appellate review process, which involves briefing, argument, and thorough examination of the trial record, takes years in complex cases. In 2019, the California Supreme Court issued its ruling in the appeal of Socorro Caro's conviction and sentence. The court upheld both the conviction and the death sentence. The ruling confirmed that the trial had been conducted without reversible error, that the evidence supported the jury's findings, and that the sentence of death as imposed was legally sound under California law. Socorro Caro remained on California's death row following that ruling. It should be noted, as a matter of accuracy and public record, that California's death row is a place where legal proceedings continue long after a sentence is imposed. California has not carried out an execution since 2006, and the state has been engaged in an ongoing legal and political debate about the future of capital punishment. As of the time this documentary was produced, Socorro Caro remained on death row, where she has been held since the completion of her trial more than 2 decades ago. The 3 children who lost their lives on the night of November 22, 1999, aged 5, 8, and 11, were sleeping in their beds when their lives ended. They were children. They were not participants in their parents' conflict. They were not responsible for whatever tensions existed inside that household. They were simply children, asleep, in what should have been the safest place in their world. That their lives ended there is a fact that 2 decades of legal proceedings have not changed and cannot change. The surviving child, the eldest of Socorro Caro's 4 children, was left to carry the weight of November 22, 1999, into the rest of their life. What that weight looks like, how it has been navigated, what support was available, and whether it was adequate, these are questions that belong to private grief and private healing, not to the public record. But that surviving child is a real person, shaped by a night that no child should ever have to survive, and their presence in the larger human story of this case deserves acknowledgement. Socorro Caro is on California's death row. Her conviction and sentence have been upheld by the California Supreme Court. The legal accountability for what happened on November 22, 1999, has been fully imposed and fully reviewed. 3 children who should have woken up on the morning of November 23 never did. 2 decades later, that loss is still the center of this story. Please like this video and subscribe to Cold Case Hour. Leave a comment about this case. Your thoughts and responses are part of the community we are building around these stories of accountability and justice. Don't forget the notification bell. Case 8. Heather Maxine Barron, June 21, 2018, Los Angeles County Superior Court. In the rolling high desert landscape of Lancaster, Los Angeles County, in the spring and early summer of 2018, something was being hidden behind the walls of an ordinary-looking residential home. Something that investigators would later describe as one of the most disturbing patterns of sustained child harm they had encountered in recent years in the Antelope Valley. The case of Heather Maxine Barron and her boyfriend Kareem Leva is a case about a 10-year-old boy named Anthony Avalos. It is a case about failure, the failure of the adults who were supposed to protect him, the failure of the systems that had received information about his situation, and the failure of every opportunity that existed to intervene before June of 2018. Most of all, it is a case about Anthony, about a child who, like Gabriel Fernandez in Palmdale 5 years before him, lived in the same county, in the same desert landscape, and met the same irreversible end. Anthony Avalos was 10 years old in the spring of 2018. He lived with his mother, Heather Maxine Barron, and her boyfriend, Kareem Leva, in a home in Lancaster. He had siblings. He was a child with a personality, with a smile, with the particular inner life that every child carries, the thoughts, the imaginings, the small daily joys and difficulties that make up a childhood. People who knew him from school and from the neighborhood remembered him as a kid who was likable, who connected with people, who had a way about him. He was also a child who, in the months before June of 2018, had come to the attention of child welfare authorities. The Los Angeles County Department of Children and Family Services had received multiple reports about Anthony and the conditions in the Barron household. Investigators have documented that the agency received at least 13 referrals regarding Anthony's welfare over the years. Each time, as had happened in the Gabriel Fernandez case years earlier in the same county, the case was evaluated and closed without the kind of protective action that would have removed Anthony from the household. The parallels between Anthony's case and Gabriel's were not lost on child welfare advocates, policymakers, or members of the community who followed both cases closely. What was being done to Anthony Avalos in the weeks and months before June 21, 2018, was documented in extensive detail through the investigation that followed his death, through medical records, through testimony, and through the evidence gathered by investigators. Court records and trial testimony established that Anthony had been subjected to a sustained pattern of severe physical harm at the hands of Barron and Leva. He had been denied food. He had been subjected to physical harm that included being dropped on his head repeatedly and being forced to kneel on rice for extended periods as a form of punishment, a detail that became one of the most widely cited and most chilling aspects of the case in media coverage of the trial. He had been isolated. He had been harmed systematically and over a significant period of time. On June 21, 2018, Anthony Avalos was brought to a hospital in Lancaster. He was unresponsive. He had suffered catastrophic physical harm that medical personnel were unable to reverse. He was declared dead. He was 10 years old. Heather Maxine Barron and Kareem Leva were both arrested and charged with murder in connection with Anthony's death. They were also charged with felony child abuse charges relating to the harm done to Anthony's siblings, who were also found to have suffered abuse. The cases against both defendants were prosecuted in Los Angeles County Superior Court in a proceeding that drew significant public and media attention. The trial included extensive forensic testimony, medical evidence, and accounts from multiple witnesses who had interacted with Anthony and the household in the period leading up to his death. Prosecutors methodically documented the pattern of harm that had been inflicted on Anthony and argued that both Barron and Leva bore full criminal responsibility for his death. The jury agreed. In March of 2023, both Heather Maxine Barron and Kareem Leva were sentenced to life in prison without the possibility of parole in Los Angeles County Superior Court. The sentences were handed down by a judge who, in the sentencing hearing, addressed the nature of what had been done to Anthony directly and without qualification. Both defendants will spend the rest of their natural lives in California state correctional facilities. The case of Anthony Avalos, like the case of Gabriel Fernandez before it, prompted renewed and urgent calls for reform of the Los Angeles County child welfare system. The fact that both children had been known to the Department of Children and Family Services, that both had generated multiple reports, multiple referrals, multiple opportunities for intervention, and that in both cases the system had failed to act protectively enough to save the child's life, was a source of deep and sustained community anger. It was also the foundation for policy conversations about caseloads, training, accountability mechanisms, and the criteria used to evaluate risk in child welfare investigations. The Los Angeles County Board of Supervisors and child welfare officials undertook reviews and reform efforts in the aftermath of Anthony's death, just as they had in the aftermath of Gabriel's. Whether those reforms have been adequate, whether the system that existed when Anthony Avalos was alive is meaningfully different from the system that exists today, is a question that child welfare advocates, social work professionals, and community organizations continue to examine and debate. Anthony Avalos would have been 16 years old in 2024. He would have been navigating the particular landscape of mid-adolescence, the friendships, the interests, the sense of a future beginning to come into focus that defines that age. He never got there. He was 10 years old when the adults in his home failed him catastrophically, and when the systems that had been given information about his situation failed to act in time. His name, like Gabriel's, has become part of the ongoing conversation about child welfare in Los Angeles County. His case is cited in training materials, in policy discussions, in the arguments made by advocates who are still fighting for the reforms that Anthony's death made more urgent. That is not a sufficient legacy for a 10-year-old boy, but it is what the public record makes possible. The insistence that his story be told, that his name be remembered, and that the systems responsible for protecting children like him be held accountable for the gaps that cost him his life. Heather Maxine Barron is serving life without parole. Kareem Leva is serving life without parole. The court has spoken. Anthony Avalos is remembered. If you have concerns about the welfare of a child, please contact the Child Help National Child Abuse Hotline at 1-800-422-4453. Available 24 hours a day. Every call is confidential. Every call matters. Please like this video and subscribe to Cold Case Hour. Share this video with someone who cares about child safety and justice. Leave a comment and let us know your thoughts. Don't forget to hit the notification bell. Case 9. Maya Hernandez, June 2025, Kern County Superior Court. There is a category of tragedy that arrives in courtrooms and public records not through the deliberate exercise of cruelty, but through the devastating consequences of neglect, through what was not done, what was not considered, what was not prioritized in a moment when a child's life depended entirely on an adult's judgment. The case of Maya Hernandez, which came to the attention of law enforcement in Bakersfield, Kern County, in the summer of 2025, falls into that category. It is a case that resulted in the death of a 1-year-old child, a baby who had no ability to protect himself, no ability to signal distress through any means his mother could reach, and no recourse against the consequences of the choice that was made on the morning his mother left him in a vehicle in the summer heat of California's Central Valley. Bakersfield is the largest city in Kern County, located in the southern portion of California's San Joaquin Valley, approximately 100 miles north of Los Angeles. It is an agricultural and oil industry city, a working-class community with deep roots in California's Central Valley culture. The summer heat in Bakersfield is among the most severe in the state. Temperatures regularly exceed 100 degrees Fahrenheit during the summer months, creating conditions in which the interior of a parked vehicle can reach temperatures lethal to a young child within minutes. Maya Hernandez was the mother of a 1-year-old son. In June of 2025, she left her infant son in a parked vehicle while she attended a cosmetic procedure at a nearby location. She was absent from the vehicle for more than 2 hours. During those 2 hours, in the summer heat of Bakersfield, the interior temperature of the vehicle climbed to levels that were lethal to a 1-year-old child. When Hernandez returned to the vehicle, her son had been overcome by the heat. Emergency services were called. The child did not survive. Law enforcement investigated the circumstances of the child's death. Investigators examined the timeline of events, how long the child had been in the vehicle, what the temperature conditions were during that period, and what decisions had been made that placed the child in that situation. The investigation established that the child had been left in the vehicle for a period in excess of 2 hours while his mother attended an elective cosmetic appointment. Hernandez was charged in Kern County Superior Court with a criminal offense in connection with her son's death. The charging decision, and the charge that was ultimately brought, reflected the legal and prosecutorial judgment about the nature of the conduct involved. This was not a case of deliberate harm in the way that many of the other cases in this documentary are. It was a case of a choice, a catastrophic, irreversible choice, that resulted in the death of a child. In March of 2026, Maya Hernandez appeared in Kern County Superior Court and accepted a plea agreement. She pleaded responsible to involuntary manslaughter in connection with her son's death. Under the terms of the plea, she was sentenced to 15 years in prison. The plea and sentencing brought a formal legal resolution to a case that had drawn significant attention from child safety advocates, from organizations that work to prevent child vehicular heatstroke deaths, and from the broader public. The death of a child to vehicular heatstroke is, tragically, not a rare event in the United States. Child safety organizations document these deaths annually, and their analysis of the circumstances consistently identifies several recurring factors: distraction, changes in routine, and the assumption that a sleeping or quiet child will be fine for just a few minutes. The circumstances of the Hernandez case, a parent absent for more than 2 hours while attending to a personal appointment, represent a more extended and clear-cut version of that pattern, and the criminal justice system in Kern County treated it as such. The one-year-old son at the center of this case was a baby. He was at the age when the world is just beginning to become comprehensible, when faces are recognizable, when sounds carry meaning, when the presence of a familiar adult signals safety and comfort. He depended on his mother for everything. On the morning in Bakersfield when she left him in that vehicle, he had no way to seek help, no way to escape, and no way to survive without her return. She did not return in time. He did not survive. The 15-year sentence imposed under the plea agreement represents the legal system's assessment of what accountability looks like in a case of this nature. It is a serious sentence. 15 years is a significant portion of a life. It reflects the judgment of the Kern County courts that the death of a one-year-old child through parental neglect of this duration and in these circumstances requires a serious and sustained accountability. Maya Hernandez will serve that sentence in a California correctional facility. For the child safety organizations that work to prevent vehicular heatstroke deaths, organizations that distribute car seat reminder tags, develop technological solutions like backseat reminder alarms, and advocate for public awareness campaigns, cases like this one represent exactly the kind of tragedy they work to prevent. Their message is consistent and straightforward. A child should never be left in a vehicle unattended. Not for a minute, not for 5 minutes, not for any period of time. The consequences of a moment's inattention, let alone 2 hours of deliberate absence, can be, and in too many cases are, fatal. The Hernandez case also raises questions about the adequacy of support systems for young parents, about whether the social infrastructure that surrounds mothers with young children is sufficient to meet their needs in ways that reduce the risk of choices driven by pressure, distraction, or a failure to fully appreciate the danger that heat poses to very young children. These are not questions that excuse what happened. They are questions that child safety advocates ask because prevention requires understanding the full context of the conditions that produce tragedy. Maya Hernandez is serving a 15-year sentence in a California correctional facility. Her one-year-old son is gone. The Kern County courts have delivered their judgment. For child safety resources and information about preventing vehicular heatstroke, the organization Kids and Car Safety maintains a hotline and educational resources at kidsandcars.org. The National Highway Traffic Safety Administration also provides resources at nhtsa.gov. Please use them. Please share them. Please like this video and subscribe to Cold Case Hour. This case, like every case we cover, is a reminder of how precious and vulnerable young lives are and how seriously that vulnerability demands to be taken. Leave a comment and don't forget to hit the notification bell. Case 10, Veronica Aguilar, August 22, 2016, Los Angeles County Superior Court. There are cases in the history of Los Angeles County that arrive in the public record with a kind of stunned incomprehension. Cases where the facts, assembled from police reports and medical records and court testimony, describe a reality so far removed from anything that resembles the ordinary that the human mind struggles to hold them alongside the familiar images of everyday city life. The case of Veronica Aguilar, which came to light on August 22, 2016, in the Echo Park neighborhood of Los Angeles, is precisely that kind of case. It is a case about a child named Jonathan, an 11-year-old boy who had not attended school in years, who had not seen sunlight in years, who had not eaten a full meal in years, and who was found on that August day in a condition that caused the medical professionals and law enforcement officers who discovered him to describe the scene as one of the most shocking of their professional careers. Echo Park is a neighborhood that sits just northwest of downtown Los Angeles, one of the city's most densely populated and culturally layered communities. It is a neighborhood of hillside streets and small houses and apartments packed closely together, of community gardens and murals, and the particular urban texture of a place where longtime residents and newcomers share the same sidewalks. It is a neighborhood where life happens in close quarters, where the sounds of a household carry through walls and windows, where neighbors are aware of each other's comings and goings in ways that are natural to dense urban living. That proximity, that closeness, makes what happened to Jonathan Aguilar over a period of years all the more difficult to fully comprehend. Jonathan was 11 years old when he was found on August 22, 2016. He had not been in school since he was approximately 8 years old. For 3 years, for more than 1,000 days, Jonathan had been confined to a closet inside the Echo Park home where he lived with his mother, Veronica Aguilar, and his siblings. During those 3 years, he had been systematically denied food. He had been sedated with herbal sleep aids, an act designed, investigators determined, to keep him compliant and quiet in the confined space. He had been isolated from the world, from sunlight, from other children, from any of the ordinary textures of childhood and adolescence that he should have been experiencing. When emergency services and law enforcement personnel entered the home and found Jonathan, they found a child who weighed 34 pounds. 11 years old. 34 pounds. Medical professionals who examined him described his condition as consistent with profound, extended starvation and physical neglect. He was taken immediately to a medical facility where teams worked to stabilize him. His condition upon arrival was critical. Jonathan Aguilar did not survive. He was 11 years old. The injuries caused by years of starvation and deprivation were too severe for his body to overcome, even after medical intervention. He lost his life in the days following his discovery in that closet. The investigation that followed was extensive and meticulous. Law enforcement and child welfare investigators worked to reconstruct what had happened in that Echo Park home over the 3-year period during which Jonathan had been confined. They interviewed neighbors, family members, and others connected to the household. They gathered physical evidence from inside the residence. They examined records, school records that showed Jonathan's absence, welfare records, any documentation that might illuminate how a child had vanished from the visible world for 3 years in a densely populated urban neighborhood without triggering a protective intervention. The questions that investigation raised about how a child can disappear from school, from public life, from the awareness of neighbors and institutional systems, for 3 years without a rescue, are among the most difficult and important questions this case poses. Echo Park is not a remote location. It is a neighborhood within miles of downtown Los Angeles, surrounded by schools and social services and community organizations. Jonathan's absence from those institutions, his complete disappearance from the grid of institutional visibility that normally tracks the lives of children, is part of the case's most troubling legacy. Veronica Aguilar was arrested and charged in Los Angeles County Superior Court with murder and torture. The torture charge, in California law, requires proof of sustained and deliberate infliction of severe harm with the intent to cause cruel suffering, a standard that the evidence gathered in Jonathan's case was deemed to meet. The prosecution built its case on the physical evidence of Jonathan's condition, the medical testimony about the nature and duration of the harm he had suffered, and the evidence of deliberate confinement and sedation that established the intentional nature of what had been done. Veronica Aguilar was convicted of murder and torture in Los Angeles County Superior Court. She was sentenced to life in prison, with a minimum of 25 years before parole eligibility. The sentence reflected the court's determination that the deliberate, sustained harm inflicted on Jonathan over 3 years constituted one of the most serious categories of child abuse that the legal system is called upon to address. The case of Jonathan Aguilar has become a significant reference point in discussions about school attendance enforcement, mandatory reporting obligations, and the capacity of child welfare systems to detect and respond to the hidden child. The child who has been deliberately isolated from institutional visibility by the adults responsible for their care. Child safety advocates have pointed to this case in arguing for stronger mechanisms to identify children who stop appearing in school and other institutional contexts, and for more aggressive follow-up when children disappear from those systems without explanation. The Child Help National Child Abuse Hotline, 1-800-422-4453, accepts reports from anyone with concerns about a child's welfare. School attendance officials, child welfare agencies, and law enforcement all have roles to play in identifying children who have been hidden from institutional view. The lesson of Jonathan's case is clear and urgent. When a child disappears from school, from community life, from the visibility that institutional systems provide, that disappearance is a warning sign that demands a response. California has strengthened its school attendance enforcement mechanisms and improved interagency communication in the years since Jonathan's case came to light. Advocates continue to push for further reforms. The institutional memory of what happened to Jonathan Aguilar is part of the argument for why those reforms matter. Jonathan was 11 years old. He had been in that closet since he was approximately 8 years old. He had spent a significant portion of his conscious childhood in confinement, in darkness, in hunger, in conditions that no child, anywhere, at any time, should ever have to endure. He was found. He was discovered. But the discovery came too late to save him. Veronica Aguilar is in prison. The court imposed a sentence that reflects the severity of what she did to her son. The accountability that the Los Angeles County justice system delivered in this case is as substantial as the law allows. But accountability, however serious, cannot give Jonathan back. It cannot restore the years he lost in that closet or the years of life that were taken from him before he could grow up. What it can do, what the public telling of his story can do, is insist that the systems responsible for protecting children be strong enough, thorough enough, and vigilant enough to find the next Jonathan before it is too late. That is the purpose this case serves in the public record. That is the reason Cold Case Hour tells these stories. Not for shock, not for spectacle, but because these children deserve to be remembered, and because the communities that failed to protect them deserve to understand why. If you are aware of a child who has stopped attending school or who appears to have disappeared from community life, please contact your local school district's attendance office, your county's Child Protective Services, or the Child Help National Child Abuse Hotline at 1-800-422-4453. Hidden children exist. They need to be found. You may be the only person in a position to make that call. Jonathan Aguilar is remembered. Veronica Aguilar is imprisoned. And the community of Los Angeles carries the obligation of his story forward, into the policy conversations, into the institutional reforms, into the daily choices that communities make about how seriously they take the safety of every child within their reach. Thank you for watching this full documentary on Cold Case Hour. 10 cases, 10 children, 10 stories of loss, of accountability, and of the ongoing, imperfect, necessary work of the justice system in Los Angeles County. If this documentary has moved you, if it has made you think about child safety, about the systems we build to protect the vulnerable, about the obligations of neighbors and institutions and communities, please take a moment right now to like this video, leave a comment, and subscribe to Cold Case Hour. Hit the notification bell so you never miss a new episode. This channel exists because these stories matter. Because the children at the center of them deserve to be remembered. Because the communities where these events occurred deserve honest and serious documentation of what happened and what accountability followed. We will keep telling these stories. We will keep covering the cases. We will keep coming back to Los Angeles County, to California, and to courtrooms across the country, because awareness is protection, and because every view, every subscription, every share is a vote for the kind of serious, responsible, dignity-centered, true crime documentary content that Cold Case Hour is committed to producing. Thank you. See you in the next episode.